Good evening. Welcome to the Law Awareness Weeks at CDC 2025. This webinar is part of Law Awareness Weeks at CDC 2025. It is a collaboration between Pro Bono SG, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences, Faculty of Law, School of Law, Singapore Management University School of Law, the Singapore Corporate Counsel Association Pro Bono Chapter, and the Singapore Association of Social Workers, supported by the People's Association. I am Jannelle Lau and I am your host for this webinar. Today's webinar is Marriage and Divorce, Understanding Your Rights, Sharia Law. As you can see, we have many more webinars coming up. If you are interested in any of the upcoming webinar topics, you can visit go.gov.sg, law, CDC, or click on the link shared in the chat function. Before we start, some housekeeping matters. First, we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any point during the webinar and also upvote any questions that interest you. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in our event passcode, which is Law CDC 2505, as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch the Pigeonhole Live on your device. If you are viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Lastly, please note that today's discussion is not intended to substitute any form of professional or legal advice. If you require specific legal advice, please consult a lawyer. With that, I would like to introduce our panelists for today's webinar, Ahmad Nizam Abbas and Muhammad Al-Hakim Abdul Kadir. Ahmad Nizam Abbas is the Managing Director of Crescent Law Chambers and has been practicing law for more than 30 years. His book, Muslim Family Law in Singapore, was published in 2022. He teaches this subject at SUSS and has spoken at various conferences organized by NUS and SMU law schools. He is also the principal examiner on the subject Muslim Family and Succession Law in Singapore at the Part B course for all would-be lawyers. Muhammad Al-Hakim Abdul Kadir is a social worker with counselling background. His journey in the social service sector began at a family service centre, FSC, where he gained extensive experience addressing a wide range of issues, from financial instability to domestic violence. Driven by a passion for mental wellness, he transitioned to a community intervention team, COMIT, where he worked closely with individuals and their families affected by mental health conditions. In his current role at FEM at FSC PPIS, he specializes in offering psycho-emotional support, helping individuals and families navigate their unique circumstances with empathy and expertise. Nizam and Hakim, thank you for joining us today.
Right. Thank you for having us.
Thank you as well.
Before we begin, I would like to briefly outline the areas that we are discussing. Some of you may be thinking of starting divorce proceedings, or some of you may be midway through it. You may be feeling lost or confused, or just plain frustrated. The purpose of this webinar is primarily for our participants today to learn about and understand the divorce process in the Syariah Court and what the court does, which can be different from the process and laws elsewhere. So I will be looking forward to learning a bit more about this topic from both our speakers. In this webinar, we'll be only focusing on the process and laws in Singapore. We may also touch on the emotional and well-being aspects of divorce. As such, if time permits, our agenda for today is Sharia divorce in Singapore and a quick overview of the process. And we also discuss some tips and strategies to overcome the challenges while undergoing the process of divorce. We will then discuss remaining healthy mentally and prioritizing your well-being and those around you, such as your children. So we also have time for Q&A. So please keep your questions coming. And with that, let's begin. So maybe we could start with some of the biggest misconception of Sharia law or Sharia divorce that I would like to clarify.
Right. Okay. Sometimes when would-be applicants, they come to see me, right? Generally the ladies, sometimes they come to the office and then they start off with, I've thought long and hard and I want to go through a divorce. But my husband, right, what he told me is that, look, if if I don't agree to divorce, you will never get a divorce. So there's a huge misconception that only the man can divorce the wife. Another misconception would be, if you get the divorce, if you want a divorce, then you're not going to get a single cent because I will not give you a single cent. So even in this day and age, right, I have ladies who come to see me and they think, right, that the entire system, the entire Muslim law is against them. So I will have to spend a lot of time processing it and explain to them that even if your husband, right, does not pronounce the talaq, there are ways for a wife to get a divorce from the husband. And even if you have not paid a single cent for the house, because that's what the husbands normally threaten them, right? Oh, you've not paid anything, I'm the breadwinner, so you get nothing. And some of them think it's true. Then what I do is that I dispel that and I said, look, even if you have not paid a single cent, right, the judge will give you a share of the assets.
That's great to know. Let's go on to Hakim.
I think with regards to from our perspective on FAMED FSC itself, right, we provide counselling for families at various stages of their journey, right, in terms of pre-divorce counselling, which is the discernment counselling, or even post during the divorce itself, we do provide support for them, and as well as post-divorce counselling. And at each stage, they have different needs. They come in with different needs, and the objective or the goal of the counseling itself differs from at different stages itself. So that's where FAMED FSC counselors at FAMED FSC come in to support them. Yeah.
And I think one of the points that most people come about is whether it's offered to Singaporeans or...
Yeah, for the counselling support provided at FAMED FSC, it provides support. It is free of charge to Singapore citizens as well as PR. As long as one of the family members are Singapore citizens, then they are eligible for those support. Yeah.
Jannelle, if I may at this point in time, right, Hakim has just brought out this counselling that is offered and that what his agency offers. If I may add, right, before a case comes to the Syariah Court of Singapore, it is actually mandatory, it is compulsory for parties to actually undergo counselling. So in other words, the law is now that without a counselling certificate, a completion of counselling certificate, the Syariah Court will not even allow you to start a divorce. Now, why is that so? I think it is part of a public policy so that people don't do things in haste, right? And that before you commence divorce proceedings, there will be expert guidance given to you, right? You will be directed to attend counseling at certain agencies, and there the counselors will walk you through the steps and make you ask questions of yourself, right? Have I really thought through all this? Do I know, right, at the end of the day, if I do go through a divorce, right, what are the things that will happen, the consequences of going through this? So it's not something which people should be hasty about, right? But there is a machinery, there is a systemic approach for people to get guidance, right? And only therefore, when a person who intends to divorce gets the certificate of completion, then will he or she be allowed to file a formal divorce application.
Yeah. I think to add on with what Mr. Ahmad Nizam shared earlier, I think now even there's another layer, even for prior to application submission of the divorce application, which we call it discernment counselling. So this discernment counselling is a short-term counselling where the focus is more on the decision, facilitating couples to make the decision whether to file for a divorce or not, whether they are leading towards divorce or not. So only then so now we are seeing a trend of whereby couples coming in calling us, hey, I need some decision making help, whether to divorce or not. Then after that they decide, okay, maybe divorce is an option. Then only then they will still log into the Syariah Court portal to submit the application for divorce, and that's where what Mr. Ahmad Nizam mentioned earlier about the mandatory counselling program they still need to go through. Yeah.
Okay, and that brings us to a topic that is coming up in our Q&A session so far, which is what about domestic violence, or when people feel that there is some abuse happening and they have to still go through counseling
Okay.
with abuse?
So I'll take it from the legal point of view. Then maybe Hakim can take from the counseling point of view, right? Right. So the process is this: the Syariah Court of Singapore handles divorces, but the Syariah Court of Singapore does not handle the violence in itself, right? So what happens is that the Muslim parties, they have to go to the Family Justice Court. So they go to the Family Justice to apply for what is known as a PPO, a personal protection order. So it can be concurrent. You can have a divorce process that goes and runs at the same time or parallel with a PPO application in the Family Justice Court. So yes, you can use the incidence of violence maybe to ask for divorce under the grounds of divorce. But the Syariah Court of Singapore does not issue a protection order. The protection order is issued by the Family Justice Courts, in which Muslims can go to and obtain an order from that. So it's not surprising sometimes where you hear Muslims going to court and say, I want a divorce. And then they go to Family Justice Court and say, I want also a protection order. And then either before or along the way, they meet people like Mr. Hakim, who can then give very practical advice where there are real life issues of violence in their lives.
Yeah, and I think to add on with what being shared, I think from the counseling perspective, whenever there's violence involved, our main priority work is to ensure that the safety is there, for the family members, especially for the children. Ensure that those safety are being managed. Is being discussed in the counseling platform. Ensure that the safety plan is there. Ensure that there's no escalation. Then only then when those issues are being talked about, then we will talk about the divorce lah. On other decision making issues.
Okay, so if there's allegations of abuse, let's say physical, emotional, domestic, even before the proceedings are started, do they still have to go through counseling?
Yes. Okay, because the counseling, the pre-Syariah Court counseling, that focuses on the decision to divorce. So they are still required to go through that. So I see where you're coming from, because it can be a bit overwhelming, let's say for a lady, because she wants a divorce quickly, but she's told, you can't file a divorce until you give me the certificate of counseling, right? And then at the same time, she has to think about, oh, but my counsellor said I also have to go to Family Justice Court and quickly get an expedited order or a PPO, right? Because I worried about myself and over my children. So it really can be very, very a lot to handle at a single point in time. And I think that's why the counsellors are they play a very big role.
Because I think that's what I mentioned earlier. The objective of the mandatory counseling program, the objective of it is to talk about basically about co-parenting, about custody arrangement. So those are the things that are being, in terms of the objective, are very fixed, very is being structured to ensure those things are being talked about in those counseling lah. Yeah.
Okay, so having gone through the start of the process, let's go a little bit into the actual start of the legal proceedings. So maybe, Nizam, could you start with a quick walkthrough of maybe the divorce process?
So let's assume that the counseling is over, right? And either the lady or the gentleman, they have been issued with the counseling certificate. Then they have 6 months actually to file for a divorce. They can either do it themselves or they can use a lawyer, right, to file the application for them. And today, all applications are online. So you can actually navigate it yourself, or if you're not sure how to do it, then you can either go to Legal Aid Bureau, or you have to use a private lawyer. Now, once the divorce process starts, what's important is basically, it's not just the form filling, right? I want a divorce. Because the form can be a little bit intimidating for some, because under the column reasons for divorce, right, you should actually put down reasons that would be recognized under Muslim law. And not everybody will be familiar with that. Okay, sometimes people use the women's charter, right, and say, oh, unreasonable behavior or separation. But under Muslim law, those are not grounds of divorce. So it's important to get proper advice on what are the grounds. Now, there could also be a situation where the husband has pronounced the talaq, which is the pronouncement of divorce, outside the court, and you can actually put that as one of the reasons that I want to register the divorce because my husband has pronounced the talaq on me. Then there could be what is known as a cerai taklek, which is a breach of marriage condition. When you look at your marriage certificate, it actually says, right, that if the husband commits injury on the wife or damages her property or he doesn't pay maintenance or he does something to cause her to lose self-respect, and if she's able to prove that one of these exists, then she's entitled to a divorce. There's also another type called fasad, where it's the court decree, where it may not be reasons relating to the husband and wife relationship, but for example, like if one party has renounced the religion or one party has gone to jail, so those are also circumstances in which the court can grant a divorce. So it is very important to actually know, right, which ground you're relying on. And I think that's where sometimes some people find it a little too heavy for them, and then I think they do need the proper legal advice. Then that is only the divorce. Then there are also the claims. So they should also be aware that there are actually 4 standard claims. Okay, the first one is called nafkah iddah, which is the maintenance while the wife is still during her iddah period, the period in which she cannot remarry. The husband has to maintain her. Then there's something called muta'ah, which is the consolatory gift. It's based on the length of marriage, based on the financial affordability of the husband. Then there will be the division of assets. For the majority of people, that would be the house. Of course, increasingly, we are seeing more and more sophisticated families. So the assets have become more sophisticated. There are stocks, shares, vehicles, overseas properties. And last but not least, and to me, certainly to many is the most important, will be the children's issue. Because you do need a court order if the parties cannot agree between themselves, right, on who's going to be the main care and control person, where the children are going to live, and the access periods for the other party. So those are the main ones. Of course, there are some smaller ones, but those are the 4 issues that a person should take note while commencing a divorce application.
If I can come in, I think hearing from Mr. Ahmad Nizam, I think just hearing itself is can be overwhelming. Yeah, there's a lot of terms and there's a lot of processes, and that's something which our clients often feedback and we mention that they are overwhelmed with the court processes, the court hearings, the lawyer appointments, and the endless documents that need to be submitted and prepared, right? So that's why it's always important for them. Sometimes when it becomes too overwhelmed, they tend to neglect about their own well-being. They put it at the back seat. Because there's a lot of things at hand. They need to do this. They need to ensure that the work commitments are done. The commitments as a parent are also being carried out. So it can be overwhelming as well. So there are times whereby in the line while the divorce happening process itself, that the Syariah Court do also refer their clients to the family advocacy to provide counselling as well. And it's a means of platform for them to talk about their emotional as well as their psychological as well.
It's great to know that there's this kind of support. So just going on along those lines, so even after we filed the divorce papers, there's still some processes to go through. And maybe, Nizam, you can talk a bit about the mediation and the estimation of timelines?
Sure. Right. So let's say you file your divorce. How convenient. This week is October the 1st. Okay. So on 1st of October, then in about 3 months' time, you will have a date called a mediation date. Now, a mediation is not counseling. Sometimes the lay person, they get confused, like, hey, I've already attended counseling. So why is it that they want us to reconcile? Is it? No. The counseling is where they get the pre-court advice or guidance, right? And for them to think about the consequences of going through a divorce. But the mediation is a stage where, okay, you already filed your divorce. Okay, so what happens is that you will be asked, right? Remember the 4 issues I said just now: the money, the house, and the children, right? And so the mediator, who is the first, will facilitate a meeting sometimes with lawyers if they are represented, but definitely with the parties as well, and to see whether these issues can be resolved. Now, if these issues can be resolved, all the issues can be resolved, actually the case ends on that day. So there is an incentive. You don't drag, you don't prolong, you don't make it protracted, right? So on the day that if parties agree on all these terms, then they will sign an agreement, and then they will appear before a judge who will then ascertain whether or not this agreement is voluntary. And if it is, the judge will say, okay, I record a consent order, and that's it. We move on to the next stage. But if there is no resolution at the mediation, then the case goes on a different track. What litigators call a hearing track, because then it goes to the next track, and then you will be given a pre-trial conference date where the judge or the registrar will give you directions to file affidavit of evidence in chief, affidavit in reply, and then fix a hearing date. And I know before Hakim says, oh, those terms are overwhelming as well. What is an affidavit, right? An affidavit is a statement, actually. It's your story, but it's under oath. Now, why is the affidavit important, right? Because when we go to court, right, a judge will go on evidence. What evidence that you bring? Now, if there is no evidence, right, and you just go to court and you just tell a story, one, it will take a lot of time, right? Can you imagine if every single case, the judge will have to listen to the story from we got married in 1997 and then we had 3 cases, and then it goes on. It cannot finish in one day. It will take days for a single case. Now, so an affidavit, you condense your life story in a written form, right? And then you exchange the story with your spouse through the lawyers. And so the important thing is that each side is given notice. These are the issues that we are going to be discussing at the hearing. And it also gives the judge the framework, right, of what the hearing will be. And in most times, the judge can make a decision based on the affidavits that have been filed, rather than go to the witness stand like you see in the movies, right? And then cross-examining and shouting at each other in court. So it's a very neat and tidy way to actually cut down the court hearing. But I can say this, writing an affidavit can be a very tedious and exhausting process for some people. And it sometimes bring out a lot of bad memories. So it can be very draining as well.
And yeah, I recall a client of mine which he was showing that, you know, like what Mr. Ahmad Nizam shared about writing the affidavit itself. There is something which is tedious, and it's also about, you know, when someone have gone through emotions of despair, disappointment, anger, it's like reliving those memories again, and it can be too overwhelming for them to fill that up lah. And I think it's something which I agree with what Mr. Ahmad Nizam mentioned earlier on is something divorce is really just about paperwork lah. There are other things that also come into play, like what I mentioned earlier, the commitments, the, you know, even when the divorce papers are signed, there are deeper issues they don't magically disappear like for example trust issue, for example poor communication. Those issues don't disappear. It's still there. It's just that on legal paper, it just states that the custody have been legally settled. Yeah. So those are the things that we do work on with clients who come into and we have this conversation with them. Yeah.
Okay, so on that note, I think we do have quite a few questions on how difficult it is on the emotional aspects during divorce, during separation, where one party refuses to engage or there's a continued abuse and they feel that this whole process prolongs their abuse. So are there any tips, strategies, comments about this?
Well, it's a very loaded question because it really depends on the actual scenario. And I think that's why, right, parties are actually incentivized to settle at the mediation stage. Okay, parties should know that if the case cannot settle at mediation, when you go into affidavit writing, like what Hakim said, it's really, really a whole new world. Okay, who likes to read something bad about yourself? But that is exactly what is going to happen when parties start to put down their life history. I mean, I've done hundreds of thousands of affidavits, I think, by now, and it's very painful because you can be as reasonable as you want, and but the thing is, you know that you have to write something because otherwise it's very unreal. You cannot be saying that everything is hunky dory, right? Then why you divorce? So like it or not, you have to actually say certain things, right? Especially when it comes to, let's say, the fight over the child, right? And this is where sometimes you see people at their ugliest, because when it comes to money, right, most of the time the content will just be, I paid how much, she didn't pay, it's more dollars and cents. But when it comes to the children, right, you see one party writing things about what do you call it, oh, she was never at home, she was going out with all her male friends, and this. And at the end of the day, right, when the wife reads it, she's going to be, is that what you think of me? And vice versa. The husband said, I come back late at night because I'm working overtime, but you're accusing me of, of enjoying life. So it's something that I always tell people, if you can settle at mediation so that we don't have to go to the next stage, right? But if you do go to the next stage, then it is a journey in which they have to be prepared that, okay, it's at the level where the judge will want to read your evidence, but you don't have to be nasty about it, right? You can be very factual, especially when it comes to, let's say, yes, I'm the main caregiver of the child. And you put examples because I attend the parent-teacher conference, I so and so, but you don't have to unnecessarily put the other person down, okay? But this is just one of the realities, lah.
But I think to answer that question, right, I think it is a challenge for someone who is going through, for example, like we mentioned, going through abuse. Then there are other also things that they are going through in a person's life. Yeah, it is a challenge to go through to manage those issues at the same time, lah. So I think that's why it's also important to seek support early, because this support can come in terms of trusted family, trusted friends and families, or even professionals, counselors, because at that platform, counseling platform, it serves as to provide a safe place for them to talk about their emotions and to learn new techniques to manage those or even regulate the emotion. Hopefully it won't get too overwhelmed. Yeah, I think I do have a client, even when divorce, upon receiving the affidavit, the originating summon, she starts questioning why am I, what have I done wrong? Have I not been a good enough wife to my husband? So those are the things that, if those thoughts are continued not being managed, it may eventually eat up on a person's self-esteem and confidence, lah.
Right.
Yeah.
Can I just pick up on a point that Hakim made just now? And because I think it's quite important, especially in the social media age, because you referred to the words support network, right? Have the right support network, because you can have friends but they may not be advising you, right, in the manner in which you should be advised. Because, I mean, we all like to have supporters. We all like to have people who have our backs. But what if your support network, right, are people who just want to see your spouse, right, like get a taste of his medicine, and then, no, you got to destroy him? Because I've seen it. I've seen a husband and wife going through a divorce, and their friends, right, will post on social media, right, all the nasty things about their own, about the friend's spouse. So you have like a whole attack, right, by some support network group. And that is actually not healthy, because what happens is that then both camps will have their own supporters, and it becomes a big thing about my supporters become your supporters. And I wish to therefore remind people that if this is the divorce, keep it between husband and wife. Yes, you do. Is in an Asian society, I know it's normal. We go and tell our father, our mother, our brother and sister. That's fine, right? And I believe they do have your best interest at heart. But be careful when they then said, no, you make sure your husband must suffer. You make sure your wife must suffer. And then they start posting things, nasty things on Facebook, on Instagram. I mean, we've seen it lah. We've seen it. I mean, even in the celebrity world, you see it, right? But that I can understand. But this is like our ordinary, Ali and Amina's. I see it as well, and it's once you start doing this, right? You actually create a monster, and it's very hard to take back. Yeah.
Yeah, I think that to add on earlier on also, because if there's really violence involved, there's abuse involved. I think we couldn't stress more that safety becomes the priority, ensuring that you are in a safe place, not only yourself but your children as well. As long and follow through the safety plan that has you been discussed with your social workers or counselors or people that you trust with. Yeah.
So building on that point, Hakim, could you just go talk a bit more about the support from the social workers available, like in terms of housing, financial items?
I think in terms of the financial, I think we are able to provide some advice. I wouldn't say advice, but in terms of some insights on how how certain systems work. So, like for example, housing, financial. But at the end of the day, we will still tell them that we do have our limitations. It's always best to get in touch with your lawyer if you are able to get engaged one, because we are aware of our limitations lah, and there's only so much that we can support them in such a manner. Yeah.
It's like a merry-go-round, right? So the counselor say, go and get help from your lawyers, and then sometimes the lawyers will get a client who tell them things like, no, but I need a HDB rental flat, and the lawyers will say, but I have no leverage with HDB on this, so please go and see your MP. So it's like a merry-go-round. Then the MP will say, go and see your counselor. Yeah, but I think jokes aside, I think we do feel for them, and because they should not be made to feel that they are being asked to go to different places. So we try to help lah. We try to help because sometimes if we've had a similar experience over housing or safety issue, right? Then we will tell them like, okay, maybe you consider if the violence case, go and approach Casa Rauda or go and approach SCWO, those who have shelters, right? And that's your immediate place to get advice from. Or if the violence involves the children, don't hesitate, go and contact MSF, right? Because they do have a child protection service, and they have the mechanism and the power to intervene. Yeah.
Okay. So thanks for that sharing. So moving on a little bit onto child care, custody and control, maybe we could expand a little bit on that. For example, on how you look after the child, the support available for the child.
Maybe I can come in here in terms of the so during the divorce itself, there's a few things that sometimes when parents are, I think that's what Mr. Nizam has highlighted earlier on in terms of the monster that's being created. Sometimes parents they fail to realize that they have little ones lah that they took care of, which the little ones are observing what's happening. They are able to pick up the tension. They are able to overhear the argument, and they eventually carry this weighted burden of their parent conflict lah. But be it marriage, be it divorce or not, be it divorce, our focus is for them to continue to work together as a team. Well, we call it cooperative co-parenting. We do have I do have clients who say, "Oh, Mr. Hakim, I already divorced. Why do I need to still go out with her, or I still need to go out with him?" It just gave the impression that we are still together. But in reality, cooperative co-parenting is not about the parent have to like each other again. We acknowledge that the marriage have already ended, but how they can work together as a team, to find out new ways for them to communicate, to find out new ways on how they can navigate or manage the conflict lah, and have a shared responsibility of looking after their children. Yeah, because again, when we talk about divorce, we often forget that they have the little ones lah, that they are also affected by the divorce itself. Yeah.
Okay. Yeah.
Do you have anything to say?
Well, I think what I'm going to do is, can I share how the courts treat the issue of the children?
Yeah.
Right. Because I think this is a huge area for a lot of people when they go to court. Now, if there is an agreement between the husband and wife, and of course things are easy, and then you just enter into a consent, right? Who looks after the child and who sees, and then when is the other party allowed to bring the child out? Now, but where there is a contest, and this is where it gets very, very emotive, and then you have tug of war issues, right? Now, what the court does, and I'm going to focus on the Syariah Court, Now, the age of the child is very important. Okay, because at the Syariah Court, when the child has reached the age of 7, we call it the Mumayis, where he's at the discerning age. He can think for himself, he understands, right? If the parents have a dispute over the child, who to look after, then the child will be interviewed. And this is a process which is a bit different from the family justice courts, because in the family justice courts, while there are instances of the judge interviewing the child, that is actually quite rare. Whereas in the Syariah Court, it's a norm, right? So any child above the age of 7, right, can actually be asked to be brought to court, and then there will be an interview process. Now, I'm glad to say that even though it can be traumatic for the child, improvements have been made over the last few years. In the past, right, the judges will interview the child all by himself or herself, and the feedback we usually get would that be is a very cursory process. The child is brought into the room, the child is asked, okay, your parents are divorcing, you want to follow father or you want to follow mother? And then that's it. That's it, right? But I think along the way, there's been a lot more thought and studies done, right? To the point where now there are 2 counselors in the Syariah Court, and they are full-time experts or child counselors, and they guide the interview process. And I think they are equipped with the right strategies, the right techniques to actually ascertain, right, behind the answers given by the child. They look at the non-verbal cues, they look at the overall. In the past, as I said, it was just a cursory, do you want to follow father or do you want to follow mother? So now it's very different. And so there's a lot more care that has been taken into the interviews. And there are such stories. I remember sharing this one because it's a real life case I did, where the child was 7. It was a boy, right? And both mother and father were fighting over the child. And what do you call it? The child obviously was 7 and did not know whether no, I love mother, I love father. And what the child had to go through was this. The mother told the child, right, if you choose father, right, then you will not see me ever again. So can you imagine a 7-year-old boy, right? How he feels when he goes to the court and the words of his mother saying that. And on the other hand, the father is also saying, I will be looking after you, I want to look after you, we can do all the stuff that boys and fathers do. And so what happened, and this is a real life incident, some people have heard this before, is that he chose the father, and the next day the mother jumped. But can you, as in jump, no?
Yeah.
So can you imagine, right, how the son is going to grow up? Because he will be wrought with guilt, right, and other feelings that he could have caused the mother to jump because he chose the father. And it's something that I will never forget. This happened to me more than 10, it was my case. It was more than 10 years ago. And until now, right, it's a reminder when I tell people, if your child is going to go for an interview, please do not use emotional blackmail. Do not use all these tricks and scaremongering tactics on your child, right? And now I'm glad to say, as I said, that the court has now the proper expertise on this. Right? So these are the children issues that and of course now the court has a lot more instruments to assist. They don't have to make a decision on their own, where the dispute is so so divisive, right? The court can say, look, I know the father says he's the best father in the world. The mother says she's the best mother in the world. I'm human, I cannot decide. So I'm going to call for what is known as a custody or the child evaluation report, commonly known as a CER. So they will be directed to attend, right, at an agency that specializes with children, right, who will then interview the children, interview the parents, and the process can take weeks, right, or at least 2 months, and then a report will be given to the court, so that the court then is a much better position than the judge doing a cursory interview with the child. So these are all the enhancement to the system where we now put the child's interest right at the forefront.
And just tagging on that, would it be right to say that the child's interest is the forefront consideration or any other?
It must be. The child's interest must always be at the forefront, not what the father's wishes are and not what the mother's wishes are. The father's and the mother's wishes, okay, while relevant, they cannot supersede or override what is in the best interest of the child. And unfortunately, in the real world, someone has to make that decision, right, as to what is in the best interest of the child. And in our system, it will be the judge. But the point I'm making now is that the judge has a lot of resources now, a lot more than in the courts in the past. They have tools, and they like a permanent counselor in court, and they have outside external agencies that can do the custody evaluation report. Yeah.
I think I have similar experience as what Nizam mentioned earlier about the 7-year-old boy. I think for my case, the boy, he's 10 years old, and I remember him saying about when we were talking about those questions, or do you want to stay with mommy or you want to stay with daddy? You know what he labeled those questions? He labeled it as a naughty question. A naughty question that he dislike or he doesn't want to be answered, right? And I think like what Mr. Nizam mentioned earlier on, right now there are various support available. There are various resources coming in. I think we also work closely with the Syariah Court, and whereby we provide feedbacks as well, and with regards to the cases at hand lah. Yeah, and in terms of when it matters with regards to the children as well, we do also provide support for children who are also who are caught in the middle between the conflicts of their parents. Where with the idea of providing them support, shielding them from the conflicts that's happening. Yeah.
Okay, and one question that has come up is do you have any strategy tips if the child has been, like you mentioned, threatened to say certain things or just along those lines?
I think to answer the question, right? If a child were to come up to us to say, "Oh, I've been being asked by my mom or my dad to say certain things to my counselor, or even to the counselor, which is myself, during our counseling session." So our angle we will come in is to identify where the child is coming from, whether what's the concern there, and whether his or her point of view about what's happening. Yeah, because most often or not, when we have conversation with children, right? Most of parents say, "Oh, my children, they don't know anything." Right? I just say this one, yeah, they just follow. But when in our many conversation with children, they are actually very much aware of what's happening at home. They know that their parents are not sleeping in the same room together. They know that their parents are, for example, Monday to when I have one is whereby Monday to Friday and Monday to Wednesday, mom will not be at home, only dad, right? But when the conversation when we were to have conversation with the parents say, "Oh, they don't know." Yeah, we just tell them that, "Oh, mom is at work or dad is at work." So it's about having this conversation with the children and providing those support to them lah. Yeah. Yeah.
On that note, Hakim, maybe you could, since you mentioned access, could you share some of your experience on discussing care and control issues like access arrangements, or I know access is a technical legal word, so maybe we should sidetrack a bit into Nizam talking a bit about access agreements.
It's excess. Okay.
Yes, and
Okay.
schooling
Sure.
arrangements, and then Hakim can share on that.
Right. Okay. So typically, right, in a care control, okay. First of all, let me just work out some of what the terms mean so that I think everybody's clear. Now, because actually, those from overseas, right, they may be very confused with your Singapore system, because in most countries, when they use the word custody, it means everything relating to the child. And it used to be the case with us until there was a 2004 case called CX and CY. So the judges in the Court of Appeal explained that, okay, in Singapore, when we use the word custody, we don't mean the looking after. We mean the responsibility as a parent. So it was sending out a signal, right, that both of you actually have custody of the child. And that's why the norm is called a joint custody. It's not both of you will look after the child, but both of you will remain as parents. Both of you will be consulted on the very important decisions over the child. For example, the education, in case there's a surgery required, a health reason. And in a case where it's a mixed marriage, it could even be on the religion of the child. So that's joint custody. Then the next level you have is what is known as care and control. This is the daily looking after. That usually is Monday to Friday. One party will have care and control, right? And then sometimes in some cases you have 1 week father, 1 week mother, 1 week father, 1 week father, mother. That's normally called shared care and control, where you alternate. Now, the thing is this: the party that does not have the care and control, that party will have access. So access is the ability or the permission to go out with the child and be with the child, just be a parent to that child, right? On the days where the care and control parent will have to just let go, right? And let the child just be with the access parent. Now, there are different types of access as well. Now, if there is a worry that the child is very young, sometimes they are infants as 2 years old, 1 year old, 3 years old, right? Then overnight access may not be given yet until the child is older. And where there are likely violence or there's been a history of violence, then sometimes the access is going to be supervised access. That means that the father can see the child, but maybe at the residence of the mother. So the father doesn't bring out the child. Okay, the child actually will remain at the family home. The father will spend a few hours, and that is called supervised access, right? There are cases whereby the child actually goes out with the father, but accompanied by another adult. That can also be supervised access. Sometimes because the father and the mother of the child, they cannot see eye to eye anymore, right? And the mother say, yes, I want supervised access, but I'm not going to be with him. I don't want. So sometimes they can agree on the choice of an uncle or an auntie, right? And sometimes, sad to say, but it's true, in some cases, even the helper, because they see it, okay, the helper is a neutral person. Now, so that's supervised access. Then the next level you have is called reasonable access. And this one can be a fixed time or without a fixed time. What do I mean by a fixed time? Is a timetable. That means from Saturday 8 a.m. to Sunday 8 a.m., for example. Now, why is this structure important? It is to benefit the child, because then the child knows, right? Okay, on this particular weekend, I am with father. And children, I think the expert is Hakim, but children, I think, thrive on stability and routine rather than the unpredictability of, am I going out with father this weekend? Is he coming? Is he not coming? So sometimes that regular routine is for their own good, right? And it also prevents squabbles, right? So that's the fixed access. And then, of course, at the highest end of the spectrum, you have what is known as the liberal access. Usually, these are for the much older kids, those in secondary school, in the poly, whatever, where you cannot just tell the child, you must see the father on this day at this time, right? He's old enough to take the bus. If the child wants to see the father at some hawker center, who can stop him? So the courts understand that the age of the child, therefore, there's no need to be structured. Just access to the father, let the father and the child sort it out on their own. So those are the different types of access, right? Then, of course, you have other access like the overseas access, but those are usually during the school holiday period and all that.
Yeah. I think in terms of we do see different variations of court order in terms of access arrangement. There is we do see a gradual in the court order states a gradual change in the access arrangement, be it, for example, from what Mr. Nizam mentioned, from supervised access to unsupervised access, eventually to overnight access, or even to overseas access. So there are such order whereby there's a gradual change, but I think at the end of it is to ensure that is to minimize as much as possible, minimize any disruption in the children's routine. Because I think I recall another child is he was saying that, oh, actually I don't like going for access arrangement because I don't get to go for holidays. Yeah. So he for I think that's then when those concerns are being brought up with the children, from the children, I think that's where the conversation happened between us and the parents, saying that okay, the child wants some time going on an overseas holiday, for example. So these are the things that we have conversation. We encourage to have conversation with the parents as well. Yeah.
Yeah. If I may, sorry, Jannelle, but I think this is also quite an important topic because there are also a lot of issues where one party denies access. And I think, Hakim, you would have come across this, right? And usually one party will say, look, I don't care what the court order says. You're not seeing the child because, and they always try to make it appear that it's in the best interest of the child. Oh, because the child is this, the child is that, and therefore the child should not be seeing you. But actually, is it really in the best interest of the child to be denied the bond and the closeness with the other parent? So it is quite common. It's not uncommon to see complaints, right, in the courts where a father says, I have been denied access. I go to the mother's house every Saturday, every weekend. I knock on the door. I can hear noise, but they don't want to open the door. And it's very exhausting and it's very draining because it's a scene that is repeated week after week. And then what happens next? The husband will, or the ex-husband will take out a comical proceeding and threaten to throw the wife in jail. And then again, they go through another round of court, and then they have to fight whether or not the breach, right, is justified or not. In that, are there really good reasons why the child should not be seeing the mother? And it just drags this whole issue down, when actually if they could have just made up their differences at the time of the divorce hearing, right, and then focus on the life after divorce. But this sometimes in some parties, the breach of access, the denial of access, right, it just aggravates matters, and it can drag for a very long time. No, we've heard of stories where a father has not seen the child for a year, more than a year, and just keeps going on and on. I mean, I'm sure you've seen this. Yes,
I couldn't agree more. I think while it's not that common, it does happen in reality, whereby even after the divorce court order has been finalized, parents going through filing variation order after variation order after variation order, or even like what Mr. Nizam mentioned about breach of court order, Bosco. So it's just the ongoing, because while some clients mention that they is when we have that conversation with client, they say, oh, they are able to, oh, I can go, I know that I can file for variation order, I can file for breach of court order, but at times they say that sometimes it get too exhausting, because it's not only financial draining because it costs money, it's also financial it's also psychological draining as well, because it's having to go up to the court, meet up with the lawyers, and is training for everyone lah.
So on that note, we actually do have a few questions on what happens before the divorce is finalized. What do access arrangements look like? And the second question is, what if the child refuses to go for access and they are under a certain age? So not like the secondary school type, but the younger children age.
right. Well, actually, during the divorce process, right? If I hope that the father and the mother of the children can be reasonable with each other, and that the children continue to see both parents. But if one parent has been denying the access of the other parent, then that parent who's been denied access can actually apply to court for what is known as an interim access order, and that's a proper court order, right? and then that order will last until the divorce hearing, where the court will then make a final order. The court can either simply continue that existing order, or they can make a new order because now they have more facts that they can take into account of. Now, but this thing about the denial of the access, maybe is I just remember it may be a good time to bring up that there have been certain changes to the law, and it was actually taken effect on the 2nd of January this year. So it's quite new. There is now something called an ECOW, enforcement of court orders, court access orders, right? This is a situation whereby in the past, if let's say the mother has not been giving access to the father, then the only option would be beside Bosco, which is the breach of Syariah Court order, which is a mediation. But the only other option was to actually go for committal, where you threaten to throw the spouse or the ex-spouse into jail. But that's it. There is no remedy for the father who's been denied access. But under these new provisions of ECOW, enforcement of court access orders, what happens is that the court can then calculate the number of days that the father has been denied access and actually make a make-up order. So if you have denied the father 52 weekends of a year, right, the court can say, I am now going to do this, go and find you, whatever. And on top of that, there will be an order that the father can see the child for the next 52. So instead of just every Saturday plus another day for 52 more times. So it's to send a warning, right? That in the past, if you don't give your access over time, okay lah, that's it lah, nothing. I just get a slap on the wrist. I just go committal, 1 day jail, a few $1,000 fine. But now, your biggest fear is going to come to life because the court is going to make the child, right, be able to see the father. So think very carefully about this. Yeah.
I think to add on with what Nizam mentioned, I think there are situations whereby the children are being denied access, especially when, for example, when maintenance are not being paid. So if you don't give me maintenance this month, then I don't allow you to see my children, your children this month. So looking at this, there's two issues that we need to identify: maintenance as well as access, and those are two different issues. And we, as much as possible, we want to acknowledge that we want to bring out that children strive when both parents are able to cooperate and are able to work together as a team. Because research has shown time and again, when parents are able to cooperate after divorce, even when they don't agree on everything, the children are able to adapt, adjust socially, emotionally, and even academically as well. Yeah, so as much as possible, we will still continue to encourage the access to continue.
Thank you both. So actually, Hakim brought up a good point about maintenance not being paid. And this is actually a question that has been asked. What happens if maintenance is not paid? What are the options available?
Well, if the father has not been paying maintenance, then of course you can go to the Family Justice Court. And this is so, right, before or even after a divorce. So if we're talking about Muslim parties here tonight, right, that's our focus, right? The Syariah Court actually does not make maintenance orders. The very simple reason is actually enforcement, because all the enforcement machinery are at the Family Justice Court. So it just makes it neater instead of going to separate different courts. When it comes to the maintenance of children, right, the mother of the children can go to the Family Justice Court, files a complaint, and then let's say she gets an order from the Family Justice Court for maintenance, let's say $1,000 for 2 children. If the father doesn't pay for a certain number of months, then she can enforce the order. Now, again, there's been developments, there have been changes in the law now. There's new maintenance enforcement processes in place, where now there can be maintenance enforcement officers who will investigate, who have been given the powers to investigate the financial capacity of, let's say, the defaulter, the father, and get the information from the banks, from the CPF board, from his employers, and then there can be an order that maybe you take from his salary and from the monies in his POSB account, etc. So the system has been enhanced. A few years ago, if the father doesn't pay, I think the only option we have was actually to throw him in jail. But again, that does not solve the root problem, right? That the mother needs the money to feed the children. So now there's a lot. There's been enhancements to this. Yeah.
Okay. So thank you for your sharing. I don't we have about half an hour left in our session. So but maybe what we'll do is we'll just talk a little bit about the last section, which is about self-care. And then after that we'll just move on and focus straight on the Q&A. So in terms of coping mechanisms and post-divorce counseling processes, maybe Hakim could share a little bit about cooperative co-parenting after divorce.
Cooperative co-parenting. Okay, so if the question is how does cooperative co-parenting looks like, right? So cooperative co-parenting looks like when parents are able to put their child's needs above their own conflict, their personal conflicts. They are able to show respect even when the emotions are raw. They are able to make joint decision together in the best interest of the children, right? Because we have seen differences in, for example, choosing of school, primary school. It can be a difficult decision to make because of how acrimonious it is between those couple, or even signing up the child for extracurricular, and it just so happened falls on the one of the parents' access days. So the parents said, "Oh, you are taking up on my access day," so I deny that signing up. So cooperative co-parenting is about making those decisions, those shared decision, because again, as what I mentioned earlier, it's not about you not it's about coming together, working as a team, even that when there are times that you disagree with each other lah. But I think to answer another question about coping, I think it's interesting to see now. It seems that there's a trend whereby we do see clients going on to Gen AI tools to find to seek cope in terms of quick advice on how to co-parent, or even crafting out messages or responses to their ex-spouse in a calmer manner. Well, we acknowledge that this AI chat tools, it is a good first point of it does provide access to, in terms of quick emotional check-in. It offers structure and ideas, but we usually encourage our clients to get balance it out with human support, which is through counseling, because counseling also it provides a safe space and also accountability for deeper healing lah. Yeah, so that is to answer your earlier question with regards to coping as well. Yeah.
Mhm.
And just a quick note for counseling, the cost involved.
Yeah, counseling, the cost involved, it is free, yeah, because it's subsidized by the Ministry of Social Family. But I think I would like to bring up something here is whereby for counseling at FEMFSC, we provide counseling for clients who are Singapore citizens. However, there are instances whereby clients who are residing outside Singapore. So for such clients, then we will not be able to provide our service because of it falls outside our jurisdiction, right? Because I think recently we do have a family that's been referred from the Syariah Court, whereby one of the parent is residing in Australia, and and so for that work, we continue to provide support for one of the parent, and also the child who still resides in Singapore. Yeah.
Thank you. And Nizam, maybe you could go on a bit about the AI topic, because it's a very hot topic in law now.
What specifically about the
Mm.
AI topic?
Do you
Uh,
see people using it
mhm.
increasingly?
Well, I think yes, because some of the emails that I get from clients themselves are so well written, right? That it's amazing. Like, wow, how did she get a law degree overnight? From the first day that she met us, and then and now through all the long things that they said. I think AI is useful in the sense that it is a first step for you to get information. But I think the be wary if that is also your last step. Okay, because I think we need to verify any advice, inverted commas, that is given over air. Because at the end of the day, right, I don't want to sound cynical, but what AI does is that it just aggregates all the information out there on the internet and everywhere. But the analysis, right, for a particular case, like a divorce where it is so unique to your own personal experience, I think I would recommend that you go and see a proper counselor, right, for your circumstance lah. Because those solutions that AI come up with may be good for some other people, but they may not be specific to yours. I mean, yeah. So it is as a first stop, as a tool, yes, it's useful, but let that not be your final stop lah. Yeah.
Thank you. I'm now going to just jump to the Q&A.
Yeah.
And related to one of the points that Hakim mentioned about one party being in Australia, maybe we can go a little bit into what happens when there's Muslim and a non-Muslim marriage.
Mm-hmm.
That's the first question. And the second one would be what happens when one party is abroad and one party is based in Singapore.
Okay. Okay. The first one, let me just clarify. The jurisdiction of the Syariah Court, right, is actually based on two limbs. One is that both parties must be Muslims, and the other one is that the marriage must have been contracted under Muslim law. Okay, and therefore, if you have a party who is a Muslim marrying a non-Muslim, then it's not the Sharia court that you go to, but actually it's the family justice court, because then that would be a civil marriage or a marriage under the ROM, and that's why there's a difference between the registry of marriages and the registry of Muslim marriages. But that's for those who are married in Singapore. Let's say sometimes a person comes from another country and says we are both Muslims, but we got married in the civil way, right? In let's say in England or America or in some other country, but we're both Muslims. I then have to say, yeah, but the second limb is not met because you went to a civil registry, right, in your country, and unless you can show proof that you also went through a Muslim ceremony, then the Singapore Sharia Court does not have the jurisdiction over you, because the Singapore Sharia Court can only dissolve a Muslim marriage and not a civil marriage. But I'm quite intrigued by your second question, because that is actually reflective of the changing demographics in Singapore. When I first started practice, and that was more than 30 years ago, right? The type of cases that one would get would typically be the man and the woman, both Singaporean Malays, living in a HDB flat, and then that's it, with 2-3 children. But now a lot of the cases that I handle actually will be where one party is not a Singaporean. So it could be a Singaporean man and a British lady, or a South African lady with an American man. I've had American woman with Saudi Arabian woman. So the permutations now, they have ceased to amaze me, because I just take it as, okay, this is yet another new dynamic. Okay, so really is like we've got many countries. So the starting point again is that we must check the fundamentals, right? Both parties must be Muslims, and then is the marriage contracted under Muslim law? If those two are met, then we go to the Sharia Court of Singapore. If they are not met, then you can't go to the Sharia Court of Singapore. Then what about a situation whereby one party says, I don't want the fight to be in Singapore. I want it to be on my home ground. So for example, just out of the blue, I say England, right? So the man says, I want it to be in England. The woman says, no, I want it to be in Singapore. And sometimes there is a battle, not on the merits of the case, no, but as to the forum, as to which court should hear this case. And that is increasing. I'm seeing it increasingly now in my practice, right? The battle as to which court should hear this case. So that's the difference in dynamics. And there are the reasons why is because sometimes there are assets in a particular country. So, and there's certain laws that apply. And sometimes it's also because of children, because although I'm a Singaporean, but my children live in England. So I want the English courts to adjudicate, because then the orders will be easier to enforce in England. So there could be practical reasons why a person wants the other court to have jurisdiction and not the Singapore court, and vice versa. There are strategic reasons why a person will say, no, but I want the Singapore court to hear my case and not the other courts. So it's a very complex issue, but it's something that fascinates me, this battle within which court should have jurisdiction.
Yes, even in the civil courts, it can be an
Yes.
issue.
Increasingly now, right, with the changing
Dem-
demographics. Yeah.
Yeah. So I'll just move on to the next question, which is what happens if some parties refuse to cooperate in the process? So they refuse to attend counselling, maybe a summons is issued and they just disappear, or if the divorce proceedings start, mediation starts, but one party just doesn't attend.
Well, in football terms, right, we call it a walkover, right? So really, right, do you want to be absent because the judge can still proceed with hearing your case? So it's not a case where if I don't come to case, nothing will happen to me. Sorry. Okay. Now let's start at the beginning. What is fundamental is that for the divorce proceedings to go to the next level, we have to prove to the judge that it has been brought to the notice of the other person. So I mean, this thing called service is very important. But if the fella evades service, right, plays hide and seek with you, we've got cases like that. They refuse. You go to the house, they refuse to accept the court documents, and then they run to another country. But now with technology, right, it's not so easy to evade service, because for Singapore it's not very easy. You know what is one way that you can serve? It's through SingPass. So you can even serve through the SingPass now. And the other one very common now, which did not exist 30 years ago, was email. So as long as you show to the judge, right, look, he's been using this email, right, for all these things. Therefore, he is the person, he will be likely to read his email. So the court will say, okay, then you serve it by email. Whether he responds or not becomes secondary. Because if he chooses to ignore, the court will say, as long as I'm satisfied that you have sent it to him, right, we will proceed. So if there are people out there who think that you can't touch me because I have not done anything in this case, sorry, really, you are in danger of considering a walkover. And you know what a walkover is, right? In effect, you are giving all the claims to the other side. So if the wife wants to have custody, care and control of the children and everything, right, and you're not there to contest it, right, what will the judge do? The judge will give to the party who is present in court. So it's not actually quite a smart move to evade service.
Okay. So perhaps I'll pass the next question to Hakim, which is about counselling. So there's a question about what about if they're not comfortable with the counsellor, are you able to change the counsellor, or what if can the counsellor refuse to issue a certificate to allow the divorce?
I think to answer that question, right, if for example, the client shared that they are not comfortable with the counselor, or for whatever reason they disagree with what the counselor shared, I think what we acknowledge that there's no one size fits all. In terms of, we acknowledge that sometimes it doesn't match between client and counselor. So there are options whereby the client are able to actually request for a change of counselor. Yeah, so those are the things that we options available to ensure that the service still do continue to be rendered to the clients, even if they don't feel comfortable, or they just want a change of counselor. Yeah.
Thank you. So going back to Nizam, we have a few questions about the grounds for divorce, and perhaps you could go through them again. The specific questions we do have are on whether there's mutual agreement, whether a prenuptial agreement exists, and whether there's like multiple reasons that can be used.
Right. Okay. I think if the person has used the word mutual agreement, right, I think that's the phrase that is now being used in a very trendy way, at the Family Justice Court, because that's now the latest mode of divorce, which is divorce by mutual agreement. Let's put aside the labeling, right? Because at the Syariah Court, okay, there has always been this concept whereby if the husband wishes to if the wife asks for a divorce and the husband agrees to pronounce the talaq, you do not need to go into any details. So it's akin to a divorce by mutual agreement in that sense, right? There's no need to wash all the dirty linen in public. No need to say why you want to end this marriage. You the parties can just agree to a very amicable divorce by the husband agreeing to pronounce the talaq on the wife, and then it will also lead to, and hopefully, an agreement on all the other ancillary issues on the nafkah eda, the muta'ah, the house and the children. And there are quite a number of cases where actually the divorce, right, is resolved by mutual agreement and on the day of the mediation. So it's there. The mechanism is there. It's just maybe different labels that both courts use. Okay. The other thing about a prenuptial, I need to be very careful here, because it's a very the word prenuptial, right, is a very Western idea, right, that has crept into various parts of the world, and in some countries in Europe, it has become a requirement that you actually need to file a prenuptial agreement before you can even marry in certain Western European countries. Now, in the West, in America, it's quite trendy with the celebrities, especially when one party is obviously has a lot of assets and the other party not so, and the party is afraid that she might or he might get a big size. Now, but in Singapore, actually, even under the civil, right, a prenuptial is actually not binding. It is not, okay, because there is a public policy reason for this. We don't want people to enter into a marriage thinking that there is an ending, thinking that you will be divorced one day. So the idea is you go into the marriage in sickness and in health, right, in good or bad, right, forever. So it's an intentional public policy not to encourage prenuptial. However, right, we do know, right, that the Singapore courts do recognize a prenup that is done if the law in the other country makes it a requirement. So we have cases where, let's say, people in France and in Belgium, they come to Singapore and say, no, we have a prenup because that's where we come from and it's a requirement there. So the Singapore courts have looked at it and upheld. Now, a prenup, however, even though it's not binding, doesn't mean that it's of no value, because a prenup can be useful in terms of the evidential value. That means you can show to the court that when we married, we agreed to do all this. But that's it. It does not mean that the judge cannot do anything more. The judge has a wide discretion, right, to do what is just and equitable. And he can say, yes, I've taken note of what you agreed to in your prenup, but I am making this order. Because, for example, right, if you have a prenup that says that the husband need not pay maintenance for the child, that may have been something agreed between the husband and the wife. But who's the party here? Who is the subject of a maintenance? Is the child, right? So the child has rights also. The child's voice needs to be heard. How can my mother and father agree that no need for the father to pay maintenance? I'm the child here. So the court is very protective of the child. So there are a lot of cases will show you that where two adults make an agreement, the judges will more often than not follow. But when parties make agreements over the children, you can see that the judge will use their very protective arms, right, and embrace the child, and I will protect the children even if it is against their own parents, if it is necessary for the child. So this prenup is not binding, but it can be used as evidence of what was in the minds of the parties at a certain point in time.
I think I have nothing else to add on. I think because this is legal terms, but I think it's interesting because when you mentioned about this prenup, it's interesting because it's a conversation I recently had with my colleagues. Because like, I do agree, it's something like is on the rise in terms of this awareness of prenups. And yeah, we do have conversation about whether is it legally binding in Singapore and how does it comes to play in Singapore as well. But I think hearing from you, I'm also learning as well. Yeah.
Okay, but there's a case I did, and it's reported in the law reports in the Syariah Court, where where the parties actually just after marriage they entered into an agreement on how they were to buy a house and who to pay what, and then what will happen to the house, and the judges have upheld that case, right? They upheld it because they said that these are two highly qualified professionals, right? So both would have made an informed decision, but more importantly, right, they both acted on that agreement. They each bought, let's say, a private property, each under one name, because they wanted to avoid ABSD and everything, right? So separate names, but they each had this set off on how each property, because they were both not of equal value, but so one had a property that was worth 4 times more than the other, but at the end so it cannot be equal in a sense, right? It cannot be you keep the one that is worth 1 million, I keep the one that is 4 million, because then it's not equal. So one of the parties said, but you look at the arrangement, we had a set off, and that must be respected. And the judges agreed. So parties can make their own private agreements as husband and wife, and it will stand up in court, but it will be very much on a case by case basis, because the courts have also refused to acknowledge private agreements between parties, where they think that it is unfair, where they think that one party has withheld certain important information, and it's like bullying the other party to force the other party to agree to something, but it led to an unjust conclusion. Okay.
Okay, thank you. So, I think we do have time for one more question before we have to wrap up. So, we have actually quite a lot of questions
Oh.
on abuse specifically.
You can just group them together.
Yeah.
Just take one go.
So there's a few questions on
Yeah.
can we shorten the process?
Okay.
They feel that one party is abusive.
Mhm.
And what happens if you don't want to, if one party also doesn't want to expose the child to the other party,
Mhm.
because, for example, the other party is in undesirable situations like jail,
Mhm.
or they feel that the other party is abusive. Okay, so if they're looking for options to, let's say, have a cleaner break, and I think that would be the question that comes up most often when there's allegations of abuse.
Right. Hakim, you want this to take first, or you want me to go first?
I think it's quite loaded, right? But in terms of because I'm reminded to this particular client, this particular family, whereby the abuse is ongoing. There's ongoing abuse, and I think that's where the safety, whenever there's abuse happening, the main priority is safety aspect. So what we did that time was to relocate the family members, or in this case to minimize the exposure of the abuse to the children, to a shelter home, for example. So is when the family are in a safe space, in a safe place, then that's where we can have that conversation going lah. With regards to whether what's their plans after, whether to work on the marriage, to work on the to abuse, or to even to decide whether to file for a divorce. So those are the steps that we would usually take on in terms of to minimize exposure, as well as to ensure that safety remains for their family members. Yeah. But I think in terms of my reducing the number of courts, I don't know that one. Mr. Nizam, if we can comment.
Well, I think the fundamental principle at the end of the day is that the judges, right, they always look first and foremost as to what is in the best interest of the child. And I don't want to make it sound like a cliche, but they really do mean it. Okay, and sometimes the children, if they need to be protected from the parents, the judges will do that. Now, I give you an example. Let's say because there are children involved and they have been abused by, let's say, one parent. Now, and the Child Protective Service comes into the picture, and they file a report at the youth court. Remember, not the divorce court, at the youth court. And the youth court, right, after listening to all the evidence, makes an order that the child be taken away from the father and be put in the foster home, for example. And there could be a period where the father is not to have access because he's just the effect on the child will be too adverse, right? So time is needed before the father and the child can be reintegrated. Now, when that happens, right, and there I've seen situations like this, the father actually goes to, let's say, the Syariah Court, and he says, "Oh, I'm going through a divorce, and I want an order that I have access." And the reason being because then I can go to CPS and say, "You see, I have an order for access." But what he doesn't realize is that the Syariah Court, once they are made aware that there is a youth court order where the father cannot see the child, the Syariah Court will follow that order, and will tell that father, right? What do you call it? As long as there is an order by the court, by the youth court, that you are not supposed to see the child for this period because of all the atrocities that you've committed on the child, right? Then the Syariah Court say we will not make an order, and they will say we will actually postpone the making of the access order until the expiry of your youth court order. And so I sometimes have very people are very confused and say, "What is this? I thought I'm here for the divorce and the access order. Why is it you are not giving me order?" Hello, there is another order in play, and that order is an order that you have to take seriously, because like he said, the safety of the child is the priority. And if the experts at the Child Protective Protection Service has come into the picture, right, the youth court has come into the picture, everything is now there, a proper safety plan is issued, you have to follow. You cannot come in by the side door, right, and say I want an access order. So these are the things that actually happen on the ground. Okay.
Yep. Thank you. And we are sadly out of time. So maybe for 1 minute each, you guys can give us with one key takeaway.
I think from my side, I think one key takeaway is we usually share with our client by, well, a divorce may end a marriage, but it doesn't end the parenting partnership, right? And without proper support, the same old issues will only follow into the new reality lah. So I think that's what we emphasize on our clients, whereby to as much as possible to work together as a team and put the best interest of the children at heart. Yeah.
Right. I mean, to follow up on what Hakim is saying, right? Okay, I would like people to remember that at the end of the day, right, the courts exist, right, because there is a dispute, right? But it does not mean that you should let your life be run by a court order. What I mean to say is this: because you and your spouse cannot get along and agree on what is the access care or the living care of the children, so the courts have had to make a decision, right? And this is what the court has said: care and control to X, access to the father, right? At the end of the day, that is a decision made by a stranger. That is a decision made by someone who only sees you that one time, that one hearing date in court, and hopefully will never see you again. But at the end of the day, like Hakim says, right, you are the parents. The child is forever your child, even in old age, right? So do you want to let your life, right, be run by that court order or that piece of paper? Or the two of you can say, look, we actually don't need this court order anymore. We are putting it one side. The two of us, let's just sit down for the good of our child. We become, well, maybe I use the word friends in a very generic way. We try to be reasonable, right? We don't fight anymore. At the end of the day, he or she is going to be our child forever, right? And there are some, I've been to some weddings, where the child or the bride or the groom is actually a child of a divorce. And I tell you, it's heartwarming on the day of the wedding, right? You see the natural father and the natural father, they've been divorced for years. And because they both love the child, right? They have become so amicable over the years, forgotten that they used to be the worst enemies, and they want the child to be happy, and they want the child to be happy for the rest of his or her life. Yeah.
That's a great story to end this session on. Thank you, Nizam. Thank you, Hakim. So we will have to bring this session to a close. Our next webinar will be Social Media and the Law, Post with Prudence, happening on Wednesday, 1st October at 7:30 p.m. Social media is a powerful tool for branding, business growth, and community engagement. But what you post, share, or promote can have real legal consequences. From running ads to working with influencers, handling online reviews, or managing customers' personal data on social media posts, understanding the legal do's and don'ts is essential for your small business or community organization and anyone who manages content online. This session will examine data protection obligations when handling customer information on social media posts, best practices for engaging influencers with clear terms, key regulations on social media marketing, and advertising standards in Singapore, how to manage customer reviews and feedback responsibly, and common pitfalls to avoid, such as defamation, harassment, and copyright infringement. Whether you are a content creator, small business owner, community organization, or social media professional, this webinar will equip you with the knowledge to post with confidence and prudence. These and many more webinars are part of Law Awareness Weeks at CDC 2025. You can scan the QR code or visit the website lawawarenessweeks.cdc.gov.sg to register for this future webinar or the many more webinars available. If you want to watch this webinar again or catch the ones that you have missed, the recordings of all the Law at CDC webinars will be made available at Pro Bono SG's YouTube channel 2 weeks after the end of this live webinar. You can check out the channel on YouTube. The link will be dropped into the chat function. At the end of this webinar, a survey form will pop up on your screen for your completion. We appreciate your comments as it will be used to improve future webinars. Lastly, after today's fantastic sharing from our panelists, and if you find that you still need legal guidance on your issues, please do write in to help@probono.sg. The email address is on the slide. We would like to again express our gratitude to Nizam and Hakim for sharing your knowledge and experience with us. With that, on behalf of Pro Bono SG, we would like to thank all of you for joining us today and have a good week ahead. Thank you.
Thank you.
Thank you.